Good morning, everybody. Today's topic is, I'm sure you're all familiar with, especially banks in Lebanon, where we have started working on since 2004 and even much before. This new project, this new circular, is more comprehensive, is intended for all businesses dealing with business securities, as well as with all registered persons within the CMA to be dealing with securities business. Before I give the word to Mr. John Carson and then our colleague Mr. Khalil Ghayouni, I would like just to remind you before we would like to keep the questions, the Q&A till the end of the presentation, where they will cover the major topics, and then after that we will open the whole discussion for the Q&A. And before you state any question, please mention your name, the institution you're coming from. Thank you. I'll leave the word now to Mr. John Carson.
Thank you, Fadi, and good morning. Let me just run through what the agenda for business conduct is. I'm going to talk about principles of conduct, governance systems, and controls. And Khalil will take over, discuss regulations on dealing with clients and record keeping, and I will finish up on client money and client assets. First of all, what do we mean by business conduct? Basically, it's the 5 topics listed here: the dealings with the customers, or what we sometimes call sales compliance, corporate governance, and the suite of systems and controls that an institution needs to have, all of its compliance and its supervision policies and procedures, record keeping, and client money rules. So the purpose of this regulation is to establish the rules and standards of conduct for securities business and for the client relationships. It also clearly sets out the policies and procedures that institutions need to establish and to implement on a continuing basis. And of course, all of those need to be written policies and procedures. The rules also set out the requirements to notify or report certain events, changes, or matters to the authority, either on a periodic basis or on an event-driven basis. And, as Fadi mentioned, establish the standards of conduct for registered persons. So that's business conduct. We also have market conduct, which we'll talk about later this morning. And generally, it's considered that the third category of regulation for institutions is financial compliance, or prudential and capital rules. So as we discussed yesterday, again, the CMA is responsible for regulating and supervising these areas only for capital markets activities. In terms of how that actually operates in practice, a bank or a financial institution could or may, it's an option, set up a subsidiary to carry out all or specific securities business. But it's not a requirement at this point, it's an option. Obviously, some institutions currently have that model in place. If you don't choose to use a subsidiary, then of course you can continue to carry out these activities within the overall institution. It's also important to mention that these regulations will replace the existing CMA decisions and BDL circulars that cover the same subject matter. So those will be repealed. As you will know from reading these, there are quite a few changes, some significant changes, based on implementing international standards here. But at the same time, we really try to build on the current circulars, which already reflect, to a large degree, international standards. And again, just to be clear, this is a regulation that only applies to the approved institutions and their registered persons. In terms of the supervision tools that primarily the control unit will use to monitor and compliance with these regulations, we're mainly talking about periodic inspections of the institutions. This should be done on a regular cycle. Hopefully it will also be done on a risk-based basis, meaning that frequency of inspection and the thoroughness of inspection would reflect the risk of a specific institution. Just to clarify though, we hear a lot of talk about risk-based regulation. Well, what does that really mean? It means that one looks at both the risk that's specific to a given institution, and that covers everything from the scope of the business, through the corporate governance, through the strength of their systems and controls, and so on. And secondly, on the major risks that are identified in the marketplace overall. So both of those kinds of firm-specific and market-wide risks need to be considered in risk-based regulation. Second component of supervision that's key is review of reports and notices filed with the CMA, and finally, of course, client complaints. At the core of the business conduct regulation are the principles of conduct that apply to institutions. I'm not going to read these because we covered this ground yesterday. These are essentially the same as the principles that apply to the licensing requirements. The point here is that the institution must continue to meet these principles on an ongoing basis. Now, you could say that these are what we call motherhood statements, or even obvious, but at the same time, it's important to recognize that these are really the core obligations of an approved institution. The detailed regulations really amplify and set out the details of how these core obligations are interpreted and need to be implemented by each institution. That means that each institution needs to think about and understand how these principles need to be applied within their own operations. Because of course, if you have a very different kind of a business, how these kinds of things might be interpreted, especially number 3, will vary, will differ. The other thing that's important to keep in mind is that in fact, these principles are enforceable standards of conduct. They are in the regulations. Now, generally, a regulator wouldn't rely on a broad principle for purposes of enforcement. One seeks to use specific requirements, detailed rules that are more black and white for that purpose. But if there is a very significant failure at a firm that isn't covered by a detailed rule, it is possible to rely on one of these general principles. In terms of corporate governance, the emphasis here is really on qualifications and accountability. It doesn't set out requirements in terms of the composition or structure of the boards of institutions. At this point, we're only contemplating those kinds of rules for the regulations that apply to public issuers, to listed companies, for example. The key thing here from a CMA point of view is the directors need to have the necessary expertise to effectively oversee the business. Not only oversee it, but to operate it. That doesn't mean that the set of directors are all going to come with the same qualifications and background, but it means that as a group, they need to bring what is necessary to the table. The second thing that directors must recognize is that they are responsible for compliance. They are the ones who need to ensure that adequate systems and controls are in place. So it is for this reason that regulators around the world in the capital markets arena, just as in the banking arena and other areas of the financial industry, regulators are increasingly looking to corporate governance as a key focus in supervising firms and ensuring that they're operated correctly. And, you know, a key reason for that is that if there is weak corporate governance, that often shows up in weak risk management, compliance controls that are lacking, and other systems and controls that are not thorough. So that's why regulators, when risk ranking regulated firms these days, also want to rate the corporate governance of an institution that they're supervising. As I mentioned in the as I mentioned with respect to banking, there are similarities in how regulators look at corporate governance. So, going back to the example of a public company or a listed company, the focus there is really on the treatment of shareholders and the rights of shareholders, particularly minority shareholders. Whereas in this arena, in the regulation of financial institutions, the focus is on the soundness of the institution, the safety of the institution, and regulatory compliance. That's why there's such a focus on governance in this type of supervision. So, hence we say, instilling a compliance culture, if you will, and sound risk management all start at the top. It's a top-down process, and the board is responsible for ensuring that effective policies and procedures are in place and are implemented and are regularly reassessed. So that means that these things should all be regular items on the board's agenda. Now, this regulation also says that the CEO of the firm and the managing director is responsible for implementation. And obviously, implementation and the activities are all delegated to staff. I'm just saying that accountability lies at the top. The rules also say that, I call it the CCO, meaning Chief Compliance Officer, but basically the head of compliance needs to have access to the board if necessary. What does that really mean? Well, one thing it means is that the CCO should regularly report to the board on the compliance program. That includes reporting major compliance issues that might exist, including certainly any issues with the CMA, and how the firm either proposes to respond to those issues or is responding to them. This regulation also means that if there is a serious issue or a serious disagreement within management on a significant compliance matter, the CCO should have the authority to raise that question with the board for consideration. Now to the systems and controls. I said yesterday that a lot of these regulations are somewhat principles-based, and this applies here. We've got a list of 10 key elements of a sound system and control system. And these are the minimum requirements. Of course, firms may choose to have more. But these regulations don't set out what needs to be in each of these sets of policies and procedures. Because obviously that's going to be specific to every business, the nature of the business, the type of license, the scale of its activities, and so on. So that isn't mandated. That is flexible based on the requirements. But nevertheless, when the CMA is going in to do an inspection or reviewing your manuals and your controls, they will be examining it on the basis that those controls need to be adequate for the specific purpose, for that business, for that type of license, for that kind of operation. Now, everyone here will already have, obviously, a set of systems and controls, compliance manuals, etc. Those will need to be adjusted to the new regulation. Or in the case of a new applicant for license, they will need to come up with their first set of systems and controls and file them with their application. The point that I want to make here is that, again, these manuals have to be customized and specific for the operation. So obviously it's not acceptable to take some kind of a manual off the shelf or from a consultant or some precedent that you find and file that with a few changes of name on the cover. That will not wash. It has to be specific to your operation. These manuals should also set out what each requirement is, or what each internal policy is, the control, if you will. What is the process for ensuring that that requirement or that policy is met? And who is responsible? Who within the firm is going to take care of that matter? The other point on the list of 10 that I want to comment on is the compliance monitoring program. You have your set of compliance policies, then you have your monitoring program. What is the difference? The difference is that this requires that the institution itself monitor compliance with regulations internally. For example, having testing of certain types of transactions or the review of certain types of activities carried out by their compliance department. So yes, the CMA is a supervisor. Yes, the CMA is doing monitoring, but it is not only the job of the CMA to monitor for compliance. It is the job of every firm to monitor for its own compliance internally. And the CMA, when doing an inspection, should check on the records that demonstrate that that kind of monitoring program is in place. I also want to comment that supervision is different from compliance. Supervision of activities is basically the same as one would understand the word from a business point of view. There needs to be ongoing supervision of all of the activities, whether they are in fact activities that are regulated or they are just general operational and business activities. Supervision, therefore, is essentially the job of the business unit or the operating unit, whereas compliance is there to support the business units and may well be the unit that carries out the compliance monitoring program. But that program should be set out in writing, in other words. What are the testing or reviewing activities that we're going to carry out? What's the scope? With what frequency are we going to do those things? And what reports need to be provided out of those reviews? A, to demonstrate that they were done, and B, to escalate any issues that might exist. As I said yesterday, the interpretation of the content, the scope, and the details of these required controls varies according to the type, nature, and scale of the business. So it is definitely, again, not a one-size-fits-all solution. And as one illustration of that, these rules specifically say that certain types of controls or entities control entities within the firm are optional, such as the four listed here: a compliance committee, an audit committee, internal audit unit, and a risk management officer. Now, we know that banks are required to have these things today, but not every approved institution is a bank or an institution of that size, scale, or complexity. And in any jurisdiction, you often have smaller brokers who don't have the complexity of business, who don't in fact have the resources or the need for the suite of controls that you would of course expect to see at a bank. So making these things optional is one effort to make the requirements reflect the scale and the complexity of an individual institution. But just generally, the way that these requirements will be interpreted by the authority will reflect that kind of approach. I just want to comment finally about outsourcing. Outsourcing of certain functions is permitted. I think we received a comment that suggests that perhaps we need to state with greater clarity or specificity what types of activities can be outsourced. But the point I want to make for now is that you cannot delegate the responsibility. If you find a consulting firm or an audit firm or what have you that is capable of carrying out a function for you, that's fine. You can delegate if you get the approval of the CMA. But the firm itself is responsible, and the firm itself needs to have a form of ongoing oversight of the party to whom functions have been delegated to make sure that it's doing the job. And I guess just finally, of course, it's up to the institution to make sure that that contractor, that person who has the delegated function, is qualified. So those are systems and controls. I'm going to hand it over to Adil to talk about the customers.
Good morning. I will be covering today two sections of the business conduct regulation. The first one is dealing with clients. Yesterday we touched base very briefly on securities advertisements, and we discussed that there are two types. The first one is the prepared securities advertisement, which should identify the name of the approved institution and should meet requirements in Annex 1, which is included in this regulation. As examples or samples of those requirements would be, if there's a mention in that particular advertisement about guarantees, it should be clear as to who are the guarantors so that the investor would understand who's behind that particular product. It should cover clearly the suitability aspect of that investment. It should cover the currency risk, if there is one, along with the total type of fees, and if there are performance fees associated with that particular product. It should be clear, fair, and not misleading. It should be approved by a designated officer of the approved institution, and the approved institution should maintain a record of all the approved securities, prepared securities advertisements. The second type of communication are the non-prepared, which I alluded to yesterday, such as meeting with clients or over the phone. And the approved institution should make sure that they are clear, fair, and not misleading. The approved institution should maintain a code of conduct for securities advertisement, for making sure that there is no undue pressure that is being conducted on the client by the registered representative. Client classification. Approved institution must qualify the clients as one of the following criteria and should maintain a record as to where those clients fall. The first one is customer, and this is a category where the client should be expecting advice from the registered representative or registered person. The execution-only customer is the second category, where that particular customer would be just transmitting or giving his instructions, and the institution, the approved institution, would be acting as an agent only, and no advice is given. The third category would be professional clients, where the approved institution must explain to that client the difference in the relationship when they sign with him as a professional client, what the client should be expecting of them, versus if they were acting with him as a customer. And that consent should be given to the approved institution in writing. As an example of a professional client, and they are, I think, at the cover of the regulation, there's 7 of them, but as a sample of them would be approved institution, exempt person, or an investment fund. So mainly these are gonna be rotating around institutions only. I'm going to touch base a little bit about the Know Your Client. the KYC form, and based on the experience that we've had in the industry so far, some of the institutions are using the KYC form as an AML tool. Within these regulations, the AML scope goes much further than that. The approved institution must obtain at least the information in Annex 4, signed and dated by the client. This is very important, the signature and the date. If the client decides not to provide the approved institution with the required information, the approved institution should reject the business. For professional clients, there are a clear sample of information that will be required in that annex, but mainly the category rotates around personal information and financial information. When it comes towards regular clients who will be relying on the advice of the institution of the registered person, besides those information that will be required from a professional client, they should get investment information and objectives. This information should be updated at least annually or whenever there is a material change. And we'll discuss material change at a later time. But mainly it's in cases financials change, if number of dependents change, retirement, income, such kind of stuff. AML laundering and terrorism financing, all institutions should comply with the objectives under Law 318 of 2001. Client agreements sets out the terms and conditions of conducting business with the clients as per Annex 2. Disclose all type of fees, and the minimum account opening is $10,000 in cash or equivalent in securities. And this is per client. The objective is not to group accounts in under one omnibus account, just literally to meet the requirements of the $10,000, which is something we've been noticing within certain institutions. The duties to clients: not use client property information, protect the confidentiality of information, and I just want to stress on this point, this particular point is not applicable to the CMA. Prevent conflict of interest through proper disclosure. Suitability: approved institution must not deal or advise or manage for a customer unless they have reasonable basis that the advice is suitable. So we go around the big picture, how you determine suitability. And I've received certain questions along the lines, well, the guy is conservative and I've given him a sovereign bond and it's excellent rating, so that's supposed to be suitable. I mean, the common sense should go beyond that, and then you would look at certain parameters. Usually it's very difficult to define it in black and white in any particular regulation. You look at the age of the client. So if you've got someone who's 80 years old and is conservative, and you give him a sovereign bond recommendation, but the maturity is 25 years, all of a sudden should pop a certain red flag that actually it does not meet that particular criteria. So it's a combination of different aspects that the institution should gather, and in certain institutions worldwide, they create certain forms to be able to conclude on something called IPS, the Investment Policy Statement, which pretty much gathers what the client is looking for based on certain parameters and information that he has submitted to the registered person, and in turn that criteria gets approved by the senior officer of that particular department, and the document comes out that captures everything that we've discussed, and the client is expected to sign on it. And actually we used to sell it that this is the insurance policy for the registered person and the institution, that this is clearly, when we opened the account, what you decided or asked us to do for you. Yes, thank you. This is applicable, obviously, I was going to get to that, but just to give you a sample of the information that will be required. Customer knowledge, financial position, customer's experience with investments, investment objectives, time horizon, risk tolerance, customer personal situations such as age and number of dependents. If a customer insists to go ahead with an execution even though the registered person told him it's not suitable for you, that registered person can go ahead with the transaction provided it is recorded. This does not apply to execution customers or professional clients. So this is only to customers that need advice from the registered person. Understanding risk. Reasonable steps to enable the customer to understand the nature of the risk involved in that particular transaction. Derivatives and speculative securities. Approved institutions should deal in derivatives with the customer till he acknowledges in writing that he understands the risk. This does not apply to execution customers or professional clients either. Margin requirements. Approved institution may take a margin transaction once he signs and dates the terms, which should include risks involved, forms in which margin may be provided, and the steps the approved institution could take in case the client does not meet the margin requirements, such as liquidating sufficient security positions to meet the margin goal. Approved institution that makes a margin transaction must take reasonable steps to ensure client is aware of risks, require the client to provide minimum margin, and monitor the margin daily. I just want to emphasize the importance of monitoring the margin daily or the portfolio valuation or equity of a client holding on a daily basis. Some institutions feel that we want to do that, but financially at the present time we cannot come up or meet with those requirements. So once we're profitable, we intend to implement such kind of requirements. This is not a luxury, this is not an option, this is a requirement that will help the institution manage risk. Authority may prescribe a higher rate of margin, and the approved institution must require the client to meet those requirements within 5 days. Authority may prohibit margin transaction on any security. Customer notes provides information required in Annex 3. Periodic reports. Approved institutions should send periodic reports to client at least every 3 months, and here we're talking or referring to managed accounts. Otherwise, we expect the institution to send a periodic statement or monthly statement. Approved institution must provide information required by Annex 5. Client complaints. Approved institution must have written procedure to ensure record of all complaints. Copy sent to the authority. The copy should be sent once the complaint is received. It's not after we try to settle with the client or address his concern and then the institution sends the complaint along with how they resolved it. So once the complaint is received, it should be sent to the authority. Timely and proper review. Client receives a written response within 60 days. Employee personal dealings. Approved institution must establish written procedures to apply all employee personal dealings and securities in accordance with Annex 6. Approved institution must not knowingly be party to any transaction in security that a client is a party to, and here I'm referring to the registered person, not to be on the opposite side of the client transaction. An employee of an approved institution must not establish an account at another approved institution unless his employer does not provide the services which the client intends to trade in. And if he decides to go and trade with another approved institution, his contracts and monthly or periodic statements should be sent to his firm or to his employer. The other section I would like to touch base on before I give it back to Mr. Carson is record keeping. Approved institutions are required to maintain record for 10 years, capable of reproduction in printed form, systems and controls covering security adequacy and must ensure adequate backup arrangements. Client records. Approved institution must maintain records, accurately record the assets and liabilities of each and all clients, contain information necessary to prepare statement for each client, assets, liabilities, and details of transactions, identify all clients' money and assets that the approved institution and custodian are responsible for, must be current at all times, and contains details of all orders entered by a client for the approved institution and the record of the suitability assessment of each transaction. So the general rule, each transaction that is recommended to a client should literally stand on its own merits that it meets the investment objective of that particular client, and we're referring to customers that require advice of a registered person. Sorry, thank you. I just want to touch base on a couple of other information, which is client access to records. Any record sent by an approved institution, or should have been sent, should be available for a client to request it and get a copy of any correspondence that he may have had with that particular institution. Inspection of records. All records must be available for inspection by the CMA. CMA may inspect records directly or through a person that we may authorize. Recording calls. Approved institution must record all client calls that include an order or instructions relating to a transaction. So we should be able, as a control unit, if, as, and when we decide to go and inspect a certain complaint or doing our periodic audits, from a sample point of view, sometimes we may choose a certain transactions for certain type of clients and require the institution to demonstrate to us how they received the call and how the call was executed. The objective of this particular exercise, especially at this day and age of technology where everybody's got the iPhone and the Blackberries, and sometimes the client may call the registered person on his cell. So that particular recording obviously may not be captured. So the rule of thumb is the following. Whenever a registered person receives such call, he should be calling directly his trading floor and make sure that the client order is captured, hearing the client transmitting the order to the trading. Back to you, John.
Okay. Thanks, Halil. We just have 2 slides quickly on client money and client assets, and then we're going to open the floor to questions. The rules on client money and assets apply to institutions that are actually holding basically cash and securities for their clients. Client money is defined as any money received from or for, in other words, on behalf of a client. And basically the rules are here to stress that other creditors or the institution don't have any claim on that money. That's client money and has to be segregated and held in a local bank. That bank can be the same bank where the client account is held, or held in the same corporate group. As long as you notify the client, that's where the cash is being held. If any cash needs to be held outside of Lebanon, again, it needs to be held in a bank for which the client has provided his consent. That means that the institution needs to have a formal agreement with each foreign bank where client money might be held as regards the administration of that money. Obviously, there needs to be maintenance of full records of all holdings of client money and related transactions, which are to be reviewed by the external auditor. Of course, we would expect by internal audit as well. The CMA also has the right to request any reports relating to the administration of client money. The regulations require that the client money holdings be confirmed at least on a weekly basis. That's really a reconciliation of the client money that is actually in the accounts with the required amounts according to a client money requirement, which is a formula that we will set out in the prudential rules. I also expect that with respect to the reports that the CMA is requiring, that those wouldn't really be ad hoc in the normal course. They would be specific reports that have to be filed on a periodic basis to enable proper supervision by the authority. And then finally, the client monthly statement of activity and holdings. Halil alluded to the requirement for managed accounts. This is for non-managed accounts. Must be sent monthly if there is activity. It's in fact okay to use electronic transmission of account statements if the client consents, and there's a full suite of required contents that are set out in Article 3520. Finally, client assets, basically any form of security or indicia of title to security such as investment certificates, anything received from the client or received on behalf of the client. This does include any collateral that the client has pledged. Of course, if the collateral has to be applied to the debt, then that collateral ceases to be a client asset, but up until that point in time, it must be treated as a client asset. Obviously here, with respect to local securities, we would expect that the mid-clear would be providing the solution, but that's an example of the general principle that client assets have to be held with a licensed custodian, an institution that has a custody license under the licensing reg, and that must be held pursuant to a custody services agreement with each client. Again, the details of the terms are in the regulations. Foreign custodians should only be used if necessary to hold securities, and of course there are many examples of situations where investors are trading in assets on, in other jurisdictions where the securities will be held there, so it's recognized that that will be necessary, but the point is that the client must agree to those securities being held with another institution. Wherever the securities are held, the records of the custodian have to make clear that the assets belong to the clients of the relevant institution. They aren't assets of the institution itself. There's a limited exception for certain foreign securities where the client agrees in writing and the foreign institution is not set up to distinguish client holdings. Reconciliation of orders for client assets, again, that needs to be done at least weekly, and what's being done there is a reconciliation as between the holdings of the client that are disclosed in the records of, for that particular client as against the records that you have from the custodians that are holding various types of securities for your clients. So that is our presentation or outline of the business conduct regulations. I guess we move on to questions.
Please, can we pass the microphone, please? Can we pass over the microphone to the gentleman? Yep. Please. Oh. Please, friend, and Dr. Asaira. Yes, Dr. Asaira, further. Please go ahead. This one is not working. Can you replace it, please? Can you replace it? أعطي غيره. Okay. Okay. Okay, please go ahead.
I have a lot of comments, by the way, but I'm going to stick to two, so I think probably a lot of people would have other comments. In fact, One relates to the concept of clients and the definition of clients, which for us is, I don't know, it's not clear at all. First, the distinction between execution and advisory. I mean, I don't see how we can, distinguish between both. I mean, they can be one transaction on the execution only, another time on the advisory. So I cannot define by opening an account for a client if it's only execution or only advisory. I don't think it's feasible, and it does not make sense for us. Second, also within the client, the professional, it looks like I've heard, I'm not sure I understood correctly, as if the professional is only institution. And I do not see why a professional client cannot be an individual worth a lot of money. And I think if you're looking for a standard all over the world, please do it like all the world. I mean, it's not, we're not different from the world. So at least when we talk about professional clients, let's do what defines a professional client. Because also here, I'm sorry, but also to mention on something suitability. The example is given was wrong, sorry to say, because if I have to advise a client 80 years old for a sovereign bond, it's wrong. It's not wrong at all. Definitely, I would advise a conservative 80 years old U.S. Treasury 30 years. I don't see what's the point. It's liquid as any deposit in the world, even better. So I don't see the concept of stability also needs to be assessed. And to continue on this, if every time I have to document the advisory, I'm not a bureaucrat. I'm a banker. I have to do my job. I have to document the way we advise. I understand the opening account, understandably. But every single thing, every time I call a client, I tell him if the euro is better today or not. I have to document it. I don't think that's even a work to be done. That's one issue of the clients. The second issue relates to the custodian. It looks to me as if MidClear, definitely we deal with MidClear, all banks here, but as if they are given monopoly on the custody on the Lebanese jurisdiction. GDRs are our sovereign, the Eurobonds are not even, I mean, I don't know how you call it, Lebanese jurisdiction or not. They can be held at MidClear, they can be held at Euroclear or Clearstream. So the point is, it is not proper to say we have only to deal with MidClear in that sense. We have the right, as long as it's approved, let's put it that way. I don't see why we should, the choice of choosing our custodian or divide assets between custodian is a risk, is a management, is definitely, it's not a regulatory point at all. I don't see why it should be done that way. Besides, when you say also that foreign custodian may hold title to assets in the approved institution names if he agrees in writing. Why it's only the foreign? Why not MidClear? I mean, I can put with MidClear also if the clients agree in the approved institution name. Why it's only the foreign institutions that have this kind of thing? Thank you.
If you don't, yeah. Thank you, Dr. Aseran. I'll attempt to handle the first one and leave custodian issue, if you don't mind. Okay, absolutely. Yeah, that's fine. I'll attempt to answer or comment on some of your questions. As far as the advisory versus execution, the objective of the exercise is sometimes we're dealing with professional clients who really may come across and say, you know what, and this is happening in a lot of international firms. And usually it attends to certain requirements where the client would say, how much would you be charging me, for example, to do a certain transaction if I don't need your advice? So I'm dealing with you as a discount broker, if you may. This is only for execution client category. And there would be a different type of fees, and this is if the institution elects to go down that road. But when the institution marks a relationship with the client as a customer relationship where he would be relying on advice, it doesn't mean that every single transaction he is going to put into that account should be receiving an advice from the advisor or registered
person, the registered person, has a responsibility in highlighting to the client that this particular transaction is outside the norm of what you have stated on your KYC from a suitability aspect of it. I just want to touch base very briefly on the issue of the example that you disagreed with my comment. What I alluded to or tried to is that if I'm dealing with a client who's 80 years old and wants to buy a 20 or 25-year maturity of a sovereign bond, you're right, that could be liquid and he can sell it anytime. But the difference is, if he is a conservative client, any change in interest rate will literally impact the value of that bond drastically. So if the objective of the profile of the client is conservative, which means that the principal has to be protected and is dear to him, and if I go and get that client in a 25-year bond or 30-year bond and he's 80 years old, then it means if he wants to get out and cash out, then he's subject to market fluctuation, which will be subject to the fluctuation of interest rate, which may impact the bottom line of the transaction. The last aspect... Sorry?
Please, let's hear his answer fully, then we'll comment on.
That's not the point. The point is, in fact, I'm raising this point exactly because the interpretation, it's fine. I mean, you have your own idea, it's fine. I'm sure that a lot of bankers would disagree 100%, and we can argue from half an hour on exactly this point, exactly that you're mentioning. My question was not that, was the assessment of suitability. In fact, who we are, I mean, we can say on suitability, you're not suitable for this kind of transaction, what you said before, I agree. But to suggest something else, I mean, it is much harder to say, okay, you have dealt with something and you cannot deal for futures, or leverage, or whatever it is, it's clear. But when you go into certain specific things, I'm not sure that the advice here is really, I mean, suitability becomes a little bit more tricky. That's my question. And I think we need to judge that. I mean, there is no one to judge it, really.
Okay, let me just comment on that. I mean, bottom line, I think essentially I agree. I'm not going to weigh into the debate about the 80-year-old. I'll leave that one alone. But I just want to be clear. No, you don't have to document every conversation with your client if that was your suggestion. That isn't the requirement. However, I believe Halil said that if you have a contentious recommendation or something where suitability is not very clear, you might want to jot down a couple of notes about that. This whole suitability area is highly contentious, as we all know. You know, my belief, based on a ton of practical experience, is that suitability is actually a pretty broad concept. You know, as an advisor, you could sit there and you could recommend hundreds of investments that are suitable for a given client. So it is actually quite a flexible concept. And if your point was that a suitability recommendation on an investment needs to be obviously wrong for somebody to attack it, I think I agree with that proposition. That's really what suitability is designed to test. You know, in North America right now, there's a huge debate around whether a standard of fiduciary duty should be applied to advisors, to brokers, which is seen to be a higher standard than suitability, because fiduciary duty really requires that in all cases you act in the best interests of the client and effectively you recommend the best security for a client. Well, who knows what the best security is? That's a pretty high standard of conduct. The suitability standard is more flexible and broader because it allows an investment recommendation to be made as long as it is overall suitable for that client's circumstances. So that's how I would see the interpretation of that requirement.
Okay.
Well, I don't want to go to the custodian yet. I didn't understand the first point on dealing versus advising. Was that a comment about the execution-only customer?
No, what I said, it's not the custody, it's the client, right? We're
Yes.
talking about the type of clients. I mean, you explained that we might have a just client, and sometimes we advise them, sometimes we execute. It's fine. Or it's only execution, which means we do not advise. I was not clear about how we can distinguish in that sense. But my most important concern is the definition of professional client. That's, I think, much more important for us.
Okay. There's no need to differentiate between advising or executing for a client if it's a standard client. The only case where that becomes an issue is the execution-only customer. If you're categorizing a person as an execution-only customer, then basically you're agreeing that, at least for that account, you're not providing advice. And elsewhere, that's basically an online trading account. The customer is making his own trading decisions and executing his own trades. With respect to the professional client, I mean, that is a debate that we're continuing internally at the CMA as to how broad that definition should be. For me, there's a good argument that it should extend to certain types of sophisticated investors or persons who have high net worth and demonstrated experience in investing in certain types of securities. So I don't know if that's the point, but that is certainly something that we continue to discuss.
Okay.
Thank you. I want two words on the classification of clients. I agree 100% with my colleague Fadi. The problem is that you request from us to classify clients at the account opening stage, and things might change. So what will happen is that automatically we will classify clients as customers, because we never know, even when a client tells us, I will seek no advice, you can never know when he will ask you a question or ask you for an advice. Could be once every year. So this is the issue. But maybe, as you said, it applies to online brokerage customers. The issue of professional clients in Lebanon is even more important than in other countries, because a lot of Lebanese wealth and I mean, you have much less institutions and corporations in Lebanon than individuals who are very wealthy and very professional. And as Fadi said, everywhere in the world, a professional client can be an individual, provided he has a minimum of liquid asset and experience in the markets. In Dubai, we can deal, FFA Private Bank can deal only in the DFSA, DFC, with professional clients, and the definition is 500,000 in liquid assets and at least 2 years of experience in the market. My questions are about, I have two things to say, two concerns actually. The first thing is about the overlapping between the supervision of the Banking Control Commission and the CMA, because today, for example, the Banking Control Commission is reviewing anything related to market conduct and business conduct as it is defined here. So the fear is, how many times are we going to answer the same questions and to show the same files, etc.? So I think, I'm sure you've thought about it, but it's a real concern, because this is a lot of energy and time for us and our teams when we have teams doing their reviews. The second issue I would like to tackle is that you said that the CCO should have a direct access to the board. I just wanted to point out that in the BDR regulations, it's the internal audit that has an access to the board, not the CCO. But I think it's a good idea, so you might want to review this with them. One last thing, client complaints. I urge you not to request that we send every client complaint, and I will tell you why. Over 10 client complaints, 9 are humor thing, somebody was, and then everything goes very well, etc. The risk you are taking, we want to have a very precise log of client complaints, and in our client complaint procedure, any complaint should be filed and logged and sent to the compliance officer. If we start, if the procedure is to send it, because it has been filed with the compliance officer, to the CMA, the risk is that we will have it will not be exhaustive as we would like it to be. With other regulators in other jurisdictions, sometimes when they look at their client complaint log, they say, no, you shouldn't log this, but we want to do it because we never know. Sometimes it's about the quality of service, sometimes it's not always related to real business conduct. So why don't we stick to when the CMA does the review, it goes through the log, because 20% or 90% of the complaint would have been solved by the time you come and do your review. Thank you.
Thank you. Please, Mr. Shahdan, but to pass over to Mr. Kamel. But before we.
Sorry. Hey, Max. Okay, thank you. I'd like to attempt tackling the first comment regarding the overlapping with the BCC. I think, at least from where we're coming from as a CMA, we are pretty much acting within what the Law 161 has given us as an empowerment, which is literally dealing with any activity that is related in the securities side of the business. So you can rest assured that our control unit or the CMA as a whole, and I can speak on behalf of legal, we will not even attempt going anywhere close to anything that is not related to the securities business as one. And as a matter of fact, whenever there is a product approval request, whether it is a fund or preferred shares offering or common share offering, we always, within our recommendation to the board, highlight that this needs to be approved by BDL, obviously. So as far as I can't speak on behalf of the BCC by any stretch of the imagination, whether their on-site audit may require them having exposure to certain trading activity, obviously this is between the institution and the BCC. So I just want to highlight to you our objective here is to come nowhere in duplicating the effort or the tasks that would be required by the BCC or BDL. As far as the... please, absolutely.
Just as a supplementary point from an international standards point of view, one would normally expect that there would be an MOU, a memorandum of understanding, as between the two authorities on where to draw some of these lines and going in to do supervision or inspections. So that would be the global practice, and hopefully we'll see something like that.
The other item that I would like also to comment on, which is the client complaint, which is something quite serious, obviously, and I understand fully where you're coming from, that a big chunk of the complaints could be administrative. He didn't receive his statement, or whatever the case may be. It could be really something small, but it could be something that may lead to something else. And what I mean by that, if there is an issue between the relationship of an approved institution and an investor, or a client customer, that is related towards suitability, that could be related to churning. The bottom line is we cannot just sit on the hopes and aspirations that the institution is going to settle this complaint ultimately with the client, and if it doesn't, then it surfaces and pops on our radar screen. So obviously we've taken your comment under consideration, and we will literally go back and think about it and whether see if there's anything that could be done in fine-tuning it. Thank you.
Complaints should be in writing anyway if they're real complaints, formal complaints. Maybe we need to set out some more details in the rules on complaint handling, to your point, to your question. In terms of, I don't want to debate Halil here, but in terms of the question about when should the complaint be filed, I mean, regardless of whether a complaint is filed with the CMA or not, my recommendation based on international practice would be that generally the CMA would not start to review that matter until the firm has responded to the client. The simple reason for that is that, as you said, 90% of the complaints go away at that stage, and we don't want to duplicate our efforts. So, but the point of filing would be at least the CMA is aware that the issue exists.
Thank you. And as a matter of fact, I thank you for highlighting this. That's why I mentioned in my slide that the approved institution should give a response to the client within 60 days. So filing or sending us a copy, it doesn't mean that the examination on our part starts immediately when we receive it. So that's why there's this 60-day window notice that once we have it on our record, we can follow up, have you been able to resolve it or not?
Okay. Mr. Kamel, please don't forget to mention your name, the institution you're coming.
My name is Kamal Wazni. I'm actually an ex-supervisor with the New York Stock Exchange. I worked on Wall Street. I took my Series 7s and 8. Those qualify me to be a supervisor with the New York Stock Exchange. I came late to the discussion, but my understanding is knowing your client is very important, part of the process of building the trust, especially for a country is trying to establish a market. And knowing a client by what we talked about, what is a suitable investment for the client, whether it's bond, security, derivative option, futures, currencies. This is all has to be laid out. Obviously, the concept of somebody who's older obviously cannot expose them to the higher risk. Even when you open the account, this can be clarified from the beginning. For somebody who's 80, you're not going to open an option account for him or future account or derivative account. When it comes to treasuries, we all know treasury is less risk, but we have to give a lot of assurance to the new investor. There is accountability and there is responsibility from the brokerage house to give the right advice. We don't want to see churning of account. That means see a lot of trading for generating commission. I think there should be, obviously, every department in the state, at least I know they have a compliance. They actually approve any trade that is taking place. I think my understanding, when it comes to the brokerage house, we have to be able to identify what kind of service they are providing. When you file the document, when you open the new account, is it a full brokerage house? What is the fee? And could be a limited margin on how much they charge. And then should be an account where it's actually be classified as discount broker and will be a flat fee. So those items should be spelled out clear so everybody can understand it. Thank you.
Please, Mr. Shahdan, please, then we'll come back to you ladies, and then to them, sir.
Good morning. And I will see Bijab Karir. Thank you for the great work. And I have a comment on also customer classification, which is also a joint comment with my colleague Matr Aboud. And I think, it seems to me that the CMA has adopted a mixed approach, because the way I understand the customer classification, you classify on the level of sophistication and you classify on the level of service. Execution only, advice, asset management, or portfolio management. Here, and the other classification is a classification retail, professional, and there are two schools here. You have adopted the school of two classifications. Some other countries have adopted the school of three classification. But my main question, it's not clear to me why did you adopt, with the client classification on the risk, you included execution only with this same classification, while it could be in this separate type of classification where you classify execution only, advisory, asset management, and then you classify customer based on the level of risk. That's point number one. Point number two, on the margin product, one of the things that I have a comment on the legal side, and because if you offer more margin, you need to be able to do a margin call and basically liquidate. And we have the Usul Muhakamat al-Madani, which basically says, or the civil procedure, which basically says if you need to liquidate assets, you have to go to court. And if there is a legal solution, that would allow us to basically execute the contract and apply the margin call. So we do, the margin transaction in normal situation and difficult situation completely the same way the rest of the world does it, and we don't get stuck with the situation where we have to go each time and face a client whether our execution is in compliance with the law or not. My last point is a point on suitability. Yes, it is definitely a very important responsibility of banks, financial institutions, or whoever offer a product to a client. And I've seen a number of abuses on the financial institution side, but honestly, I have seen many abuses on the client side. I have done many litigation. Every time the market goes down, there are a number of lawsuits filed against the financial institution on the basis of the product is not suitable or the transaction is not suitable. So I know that you have done a very important work, and please take into consideration, and I'm sure you have, the balance between the protection of the customer and the protection of financial institutions. And thank you.
Basically, I have Carlos Abu Jawda.
Just a minute, please. Let him.
It's the same.
It's the same context.
I will not repeat what he said. I fully concur with Shahden on this. However, also on the suitability side, the approach, if I may say, is a bit weak. Excuse how I said it, but usually rules are meant to organize relations between the two parties and to a high extent prevent disputes. When the rule is ambiguous or gray area, especially that we have a very weak or poor judicial system in terms of addressing these issues. We don't have laws to address these issues. Okay. They don't understand, the dynamics of a market. So when you insert a provision stating that there's a suitability issue, so it means that you open a big room for disputes. You go to courts, nothing will happen, and we see this very often. So what happened in Dubai, the idea that is used in Dubai in the DIFC, professional is a client who invests more than X and who has experience of more than Y. So assume that this criteria would be a threshold of 500K or 1 million K. How can someone be non-professional and invest 10 million and he's doing execution? So a clear criteria is better for an emerging market, so this is one.
Can we stop there? We have so many questions on the floor, I lose track of what we're talking about. Can we just respond to that first? Yes, in fact, I reviewed the DFSA regulations in the course of drafting these regulations, not only these business conduct regulations, but all of them. So I recognize your point.
It's a good point. As we said, or as I said earlier, we continue to look at the question of how broad the definition of professional investor should be. So we thank you for that input. Everyone who has a point of view on the definition of professional investor is encouraged to submit their written comments to us so that we can further inform our final decision.
We're satisfied. We know that you're going to address the issue, but this is a concern because, second thing, the KYC, as it was said earlier, the KYC can be an expanded one to understand the behavior or the dynamics of a client. Last thing, the main issue everyone faces in this market is the margin calls and how to enforce a decision against a client who happens to be a bad debtor. So we know that we have legal gaps in our laws, but this business conduct is only driven, if I may say, against financial institutions. No, please. We should at least put some provisions about the obligations of the client, a minimum, because he's a party to this party, if I may say, he's a member. So at least they have to abide by certain obligations, i.e. to settle margin calls on due dates, etc.
That's great, but this regulation, we don't regulate clients. I mean, this regulation doesn't apply to clients.
Definitely. No, but whenever you have an obligation against or a rule which applies on financial institutions, there should be at least this applies subject that the client has fulfilled his obligations, because a client can fail to fulfill obligations. He calls the financial institution.
Well, sure, but I mean, you have your tools for setting out the obligations of your clients, and that's the client agreement and the margin agreement.
Just a sec, please. Just a sec, please. I mean, to be honest, at one point we forgot already the issues that Mr. Jbaili.
Just on the suitability, just because I wanted to mention the same thing. Actually, what's happening is the burden has completely shifted from the customer to the bank. We understand the suitability, but we're facing an issue, and we're always arguing with the CMA that every sentence that says that the client has done his homework is being deleted. So today, we have a situation where all the burden is on the bank, and it's going to open a string of lawsuits. If today I'm an investor, the first thing I will do is sue the bank if I lose money, because any obligation on the client has been removed from all the texts.
Okay,
so we need to discuss this. No.
Okay, thank you. I just want to make sure I attend to that question because it's dear to my heart, because we've debated this at length. Yeah. I have no issue, and as a matter of fact, I highlighted in one of my slides today that at one point in time, the risk factors should be highlighted to the client, and I even discussed it yesterday in my presentation where I said that all material information should be there so that the client can take and make a decision, an informed investable decision. But with the documents that have been coming to us from the flip side of the banks to us, states clearly that the investor, before he makes a decision, should consult with his investment advisor, where the institution itself is the investment advisor. So at one point in time, and this is all in the documents, and I have them, so all the documents that's been coming to me, the burden is being transferred from the institution that quasi should be responsible for doing that advisory role to the client. So now, if we're dealing with this category and referring a little bit to Mr. Shahdan Jbaili that got lost in translation with all what's going on now, everybody taking a turn. So the issue is that if we're dealing with an execution client only, and then the offering circular is being presented to such kind of client, and such terminology is added that he should seek an investment advisory counsel or opinion before he commits, we're fine with that. But when the institution is the marketing party of that particular product and they are the advisor, then the onus of the responsibility of such kind of advice should stay with that institution. Otherwise, they cannot be the advisory. Otherwise, there will be that perception of conflict of interest. If you can...
One other question on customer category is what I perceive is the mixing between the customer based on risk classification and the inclusion of execution only, which to me a category that is separate from the rest. Execution only, advisory, asset management versus a regular client, professional client, or market counterparty using execution. The execution only is included. That's really my question. And it says clients, execution only, and professional client. It seems to me that those two categories are mixed together while they should be separate. One classification on the basis of risk, which adopt either 2 or 3, depending on whatever you decide, because here it seems that you have adopted client and professional client, while the UAE, for example, had added also a third category, which is market counterparty, and the second category, which is execution only, advisory, and asset management. While here, somehow, the two are mixed.
Okay, I think I now understand the point. So you're suggesting, if I understand it correctly, that we should have professional client and customer. Execution-only customer is a specific form of customer with limited services.
Yeah, the execution only goes in a different category, execution only, advisory, and asset management, to differentiate, the same way. I think the rest of the world differentiate, and, you and I,
Yeah, okay.
customer and type of service. Customer and type of service. Here, it seems that the two are mixed together.
Okay, well, I got the point. I think we're going to have a look at it. The key is we have to be very clear about what types of services can be provided to the execution-only customer.
Okay, we have a question back there with the lady. Yes, please.
Fatan Sulaiman, Master Capital Group. I have a question about dealing with the client's part. It says here at the mandate over a client's account that a client can authorize a different person to trade on his behalf or do transaction in his account. What if we have the same person trading on behalf of many? So is that possible?
Are you referring through a power of attorney?
Yes. So assuming I'm client A, I gave you a POA to trade on my behalf, and then client B gave you the same POA. So you end up trading for me and maybe 10 others. Is that possible?
Yes, I can see an issue as to why not. At that point in time, the responsibility of the decision was taken by the client to empower that particular individual to trade on his behalf.
Okay, perfect.
There is an issue, though, that could arise, and that is if a person is collecting all sorts of investment accounts and acting for them, is that person, in fact, in securities business and needs to be licensed?
Okay, so he has to be an IB, a licensed IB, that's what you mean?
No, I'm not saying it's clear one way or the other. It's circumstance dependent. It's fact dependent.
Okay, so yesterday you said that an IB doesn't have to have a license anymore. So if you introduce a client to a company and you take commission on that, you don't have to be licensed. What if that IB, that person, is the one that my client gave him the POA? Is that an issue?
Yeah, here we're going back to the mix. We discussed clearly yesterday that the introducing broker role will stop immediately after he introduces the relationship, and there will be no involvement whatsoever. And we've discussed this after the meeting yesterday, that if we're going to go down that aisle of what you just described, so we're closing the door that this IB is only as an IB just to get the same relationship coming back from the window through a power of attorney, which defeats the purpose of the entire exercise.
So he can't?
So he cannot, yes.
Okay, my last question is, mainly in all this draft, you mention advertising to clients in Lebanon, and everything you refer to it, you say in Lebanon. What about outside Lebanon? Can we advertise for our company for clients outside Lebanon?
Well, outside Lebanon, you'd have to look to the regulations of the jurisdiction that the person is in.
Online advertising.
Online. Sorry, I thought we discussed online advertising into Lebanon yesterday. Is that the question?
Outside Lebanon, that's my question.
Okay, outside Lebanon, you look to the laws and regulations of the other jurisdiction.
Thank you.
Any further questions? Yes, please. Could we have the microphone in here? Hey, Anhon, please.
Sira Bazzi, BLF. I would like to say a few more words about the classification of clients. First, what do you mean by professional clients? We have two categories of professional clients. The what we call.
Could you raise your voice, please, so that we can hear you properly? Thank you.
What we call contrepartie eligible or eligible counterparties that are other institutions, financial institutions, banks, and professionals. For example, these should not profit from the best execution obligation imposed on approved institutions, while other professional clients who have enough knowledge, experience in the financial markets that allow them to evaluate the risk sufficiently should profit from the best execution obligation. So these two kinds of professional clients should not be in the same category, I think, if you permit. Moreover, execution-only customer. What if a client is not a customer, is a professional client, and who wants an execution-only service? Where do we classify him? And what if a client decides to change his category? Should we, are there some criteria that allow this classification? For example, according to MiFID, there should be a minimum assets that owned by the client in order to let him change his classification from a non-professional client to a professional client. For example, in France, more than 500,000 euros to allow him to become a professional client.
Okay, let's try to answer those.
Please, I have other. On the other hand, I propose to make 6 key information apparent in the documents provided to clients: the nature of the product, the existence of guarantee, the minimum period of placement. I don't see any minimum period of placement in the draft. The risks of losing and possibility of gaining, fees and commissions, of course, and the target client. We don't see any target client here. I think also we should underline the notion of risk better in the drafts, because always the client look too much at the advantages of the investment and forgets the risks. So I think that the risks should be, especially in advertisement documents, as apparent as advantages. There was a decision from the Supreme Court of France dated 24 June 2008 related to this issue. And it makes a lot of conflicts between clients and professionals. I think also, on the other hand, we should regulate better the canvassing of financial products, soliciting of clients. When we propose financial products to clients in their homes, for example. When we go to the client and propose financial products to him, we should regulate better this issue, and we should regulate better as well the distant marketing of financial products, because studies show that they contain more risks for the client. Thank you.
Thank you.
Okay, thank you.
Let me, John, say something first, please, about the professional client, professional investors definition. we need actually to have your written input in this. That's the purpose of this conference. Actually, we had a lot of extensive discussions, whether in the board, at the board level, or whether with the heads of the departments about this definition, as well as our international expert. But we need to have written comments from your side. We had a previous meeting with the Committee of Capital Markets, and we asked for these comments, and we are still waiting for them. As well as everybody else participating in this conference, we need please to have your written comments about the definition of investor, professional investors, so that we need to take them into consideration during our discussions. As for the reply of your questions or comments, I'll leave it to Mr. Carson.
Well, actually, to your point, Fadi, I take those as basically comments and not questions, and I think they are good comments. I would not say that any of them are incorrect. It's just a question of what approach we want to take. And as you said, if we could be sure to get those comments in writing, we will definitely think about them and see if we should make some changes.
Yes.
Hi,
Yes, please.
Khalid Zaidan, Med Securities. I have two questions, actually. The first one, our current documentation allows for orders placed by clients to either be transmitted by phone, electronically, or by signed letter. Does the CMA see an issue with those three forms? I remember, actually, those forms were done between myself and Khalil many years ago. So I would like, this is my first question.
Thank you. In response to your question, if the client has signed the document that he agrees to have his order transmitted electronic, and once again, I'm not going to touch on the legal aspect of it. I think Mrs. Aoun can address that. So this becomes more of a legal security between the institution and the client. But as far as the CMA is concerned, the objective of the exercise, once again, when we say we want the orders, only the execution, not the recommendations, as Mr. Carson has touched base on, they should be recorded. So if it is transmitted electronic, if it is by phone, or the client signed the document, and this is part of the terms of agreement between the institution and the client, and it's signed and dated, we're okay with that. Mrs. Aoun, do you have that?
Electronic filing of the request is that we don't have yet e-signature, a law for the e-signature. It's not recognized yet. So this is the main issue about it.
To just continue on this specific subject, in the event, because you know how our business operates, occasionally we do have a customer that will call any of the brokers or any of his relationship managers requesting an order. That person could be away, not next to his desk. The order is executed. In some instances, we call for confirmation, all right, so the execution officer calls back for confirmation. In other instances, you know, let's say when we do our review and we discover certain trades have not been accounted for, the client actually, you know, signs whatever in terms of confirmation of that transaction, in case we don't have a proper record of it. Would this type of policy work for the CMA, or we need to make sure that the order, in fact, is entered via any of those three, you know, mediums prior to the execution?
The objective of having the order tape is not just from a regulatory point of view. It's literally a risk assessment for the entity, the approved institution. So when there is possibly a conflict of what the registered representative heard from the client, whether to buy or sell, or whether it's 10,000 or versus 1,000 shares, usually the tendency of having the backup plan, which is having the orders being taped. So if there's any conflict of misunderstanding possibly between the institution and the client, so the backup would be literally the tapes, which should reflect the order. So having back and confirming to the client that actually we bought or sold for you a certain size of transaction at a certain price, whether it's a day order, it was understood GTC order, whatever the case may be, does not help at that point in time, because you're looking at something is already executed. So you're reporting a confirmation on a transaction, and there's no means of revisiting how the order was transmitted by the client to the individual that took the order. So that's from a risk point of view between the institution and the client. In a lot of jurisdictions, and even in Saudi Arabia, no orders are being allowed unless they go directly to the dealing room. And we started thinking outside the box, okay, how about we put the guy immediately on a conference call, and this will engage automatically the recording where it could capture the order being transmitted from the client. Okay.
Yes, please go ahead.
Yes, hi, Yves Rahmi from Biblos Bank. I need to ask you about the physical shares in Lebanon, because we face this on a daily basis with our clients. We have a lot of Lebanese people who hold physical shares at home in their safe, and they pass to the bank only to get dividends, or sometimes to do the cross trade in order to give them to their children. So they don't open accounts, or we have to open them the account to do a trade and then close it. What type of clients you consider him? We have Solidaire, which is listed, Wholesale listed, some of them not listed, like Casino du Liban.
So you're opening an account just so a dividend can be processed?
Either this, or maybe to sell part of the shares.
How does that conform to the requirement that an account must be open with $10,000?
This is the problem. In Lebanon, sometimes if one has a newborn baby, he buys him 100 shares of Solidaire just as a gift, and this happens a lot.
Sorry, let me just explain one thing. In fact, the law, there is a law that says all securities must be dematerialized. That's the law. However, also there is another law that specifically said for Solidaire as if it is a different company. So it has its own law. So the point is, unfortunately, and we've tried as brokers and bankers, we've tried to really call the company and to enforce, I mean, this is, I think where CMA should do it, to enforce that all accounts, like every company in the world, should be at least dematerialized, and therefore all the securities would be paid directly to the banks. But in Solidaire, that's the example, they might have two ways. One, accounts are dematerialized, securities dematerialized, we pay through the banks, and others who hold shares in their own company. In fact, when they try to sell, and that's another problem, because when they try to sell, we are opening accounts which are transitory accounts, because exactly, there is no KYC, nothing. Then, again, because if they are opening the account, we are forcing them to have a KYC. But he's going to sell just to sell. He comes to the bank and says, okay, I want to sell. I don't want to open an account. So what we do? So this is an issue that we have faced and we have tried, but I think the CMA probably needs to address it in due time. So that's why, and it's not a question of 10,000, it's a question of a fact that a lot of people have their shares in terms of nominal.
Excuse me, but that's an exception, actually. You're you cannot apply an exception to the whole rules. That's what you're trying to say.
No, I'm saying that we should take that exception out.
Yeah, but that's an exception. I mean, this is the case of how many stocks in the market for how many transactions taking place on daily basis, right? So if we...
How many clients of that sort?
Or how many clients. So that's an exception. Probably we'll take that into consideration as part of it, but it's not the only resolution to disconsider for the KYC. That's what I mean.
Maybe the best thing would be to enforce the law that says that Solidaire should dematerialize their shares. My point was about the recording of calls. Of course, there should be a procedures, there should be the rules, etc. But accidents happen, and my fear is that my request is that we don't have a wording that would imply that if an order was not recorded or the record was lost or erased by accident, that could allow the client to refuse it, because with courts there could be other elements, éléments de preuve, I don't know how you say it in English, that could show that the client actually, first he received his statements, he received his transaction contract notes, he talked about his position. This is something that we should be careful about.
Okay, thank you. We have a question of, no? Do you want to raise a? Okay.
Excuse me, Mazen Ladani, Met Securities. I would like to ask 3 questions, please. The first one is the CMA willing to provide us, in order to avoid any misjudgment and to have a unified scheme between the financial institutions, will you provide us with an IPS form with its matrix so that we can categorize clients in a better way? My second question is, in case I was contacted by a client who is 70 years old and used to be a trader for the past years, and he used to trade frequently also after he retired. Should I refuse to open such an account, noting that he is willing to trade in derivatives? And is such a client categorized as an execution only, or is he a professional client? And in case he was an execution only client, why should I refuse such an activity for a client who is 70 years old? My third question is, as per the new laws, if I'm not mistaken, I would like to ask, banks' branch managers cannot sell or market any preferred shares, bond, or securities? Thank you. Unless they are registered under the CMA.
I'm going to attempt to address some of the issues that you raised. Did you mention IPS?
Yes.
Okay.
Yes.
I mean, we're not, as a regulator, to develop an investment policy statement for any institution. I mean, each institution vary in the method and the style as to how they reach that category of suitability or identifying what type of risk parameters. Certain institutions, international ones, would use certain diagrams whereby sitting down with the client and asking him literally 50 or 60 clients, and I've seen documents recently that thick, and I wonder sometimes how the client is able to decipher the information that's been given to him at any point in time. And this is really a serious issue. In the similar fashion, when things go to court, and the judges sometimes have been on as a special expert on tribunal, and the judge would ask, are you serious? Would you expect that client to read that kind of material to open an account? So the moral of the story is that you've got variables in your hand, and the institution should be able to develop a program, a software that literally can attend to the risk parameters of the type of business that they conduct. Between the compliance department, internal legal or external legal, this has to be developed in-house. But we're open in case you'd like to come and discuss and sit down with us, we're open for that. As far as the 70-year-old gentleman that you referred to, if the gentleman wants to trade on an execution basis only, right, and the institution is comfortable with that relationship and he's willing to sign it as such, if you remember, I said something in my slide that the client has to understand the difference in dealing or the relationship when you're dealing with him, for example, as a professional client versus a customer only, and you should get his consent in writing. So if the client is willing to give such kind of consent, then literally the decision is yours. I don't want to go and drag on. There are certain jurisdictions go beyond that where they put the responsibility, and here we're concerned about the suitability aspect and how we are literally tilting towards protecting the investor versus not being or advocating or in the best interest of institutions. There are certain responsibilities from various jurisdictions along the lines, quote unquote, you have to protect the client against his own interest, in a sense. Like if you see him willing to take a certain transaction, even if he's willing to take it, you have a responsibility to reject the business. We're not going there. And this is far from going there, so we don't want to tilt the scale from one direction to the other. So the answer to your question, yes, you can take the business, provided that the client approves and consents to it in writing. Was there a third one?
Yes. The third question was, as per the new laws, if I'm not mistaken, the bank's branch managers if they are not registered under the CMA, can they sell or market any preferred shares, bonds, or securities?
Okay, yesterday we discussed the rules of engagement, if you may, for registered persons, and we put the 10 registrable functions. Any person that's going to deal in securities is expected to pass those required exams. So if it is a branch manager or regional manager that wants to be involved in a recommendation to the client and willing to give advice and take an order from a client, he would have to meet the requirements for that registrable functions, which we covered yesterday.
Thank you.
Yes, please go ahead.
Alexandre Salem, Credit Libanais. Can we clarify a little bit this issue of custodian, local custodian versus foreign custodians, and the client approval for foreign custodians? Because it's not very clear, and it doesn't show the main objective out of it.
I'm not sure what point you're referring to in terms of what is not clear, but basically the concept is that if assets are to be held outside of Lebanon with an institution for a client, then the client must agree to those assets being held at that specific institution. Well, that's about the foreign securities. If the question is about mid-clear, mid-clear is automatically a recognized body under the capital markets law and is supposed to be supervised by the CMA. So mid-clear will not require any form of a license other than the license that they automatically receive. There's no intention to change the role of mid-clear.
You are focusing on the local custodian. We have some other counterparties in the market. It might be a foreign bank. It might be another custodian like Mid-Clear, Clearstream or Euroclear. Why you are sticking to the local custodian?
I don't understand. We're not sticking to the local custodian.
No, sorry, you are. And it is important because it is written in the regulation, and this we need to address, as if on the local securities we are forced to deposit with Mid-Clear. The question is, why is it the case? I mean, is this any monopoly type of things? Is that?
No, some of it is in the law. There is some exclusivity
Yes.
for Mid-Clear in the
Correct.
law. For the rest, we're ready to look at it again and see how we
Correct.
can address it.
That's important, but to look at it at least, to look at
But
yes.
you know, there's apart from the constraint.
May I intervene in something else? Another issue which is not important, but also one of the things that you mentioned in your regulation, the contact with clients in terms of sending them confirmation and contract notes and all this. And that's fair. It's great. The point is, whenever a customer is opening an account, we let him sign where they want, and what means and all this. And some of them insist that do not want to receive their statement. They want to keep it at the bank. What we should do in that respect?
I mean, they don't receive their statements, they keep them at the bank.
They want to keep it at the bank. Holding. It's one of the things, and we let them sign. It's signed and all this. I mean, definitely, they do not want to receive it for whatever reason. They do not want to receive it. Being a different nationality, they want to keep it from their girlfriend or wife. I don't know. But the point is, they don't.
Well, I mean, we can discuss that. It doesn't make sense to me. I mean, if the policy is that clients should review their statements and are deemed to have, after a certain period of time, to have accepted the transactions, and then we have a situation where they're not required to receive their statement, that doesn't really make sense, but we'll have a look at it.
Just a follow-up on that comment. If the client, let's say, is going away for a certain period of time, there's something we could consider, which is a temporary hold mail. So if the client is going on a trip, this is something in various regulations, and whenever the client, that period of time finishes, then that statement, which is a kind of if you may, the security blanket, which the client notifies that once he received it, that he's in agreement with the content of whatever went on in his account.
May I? Okay, I would advise you, in fact, just to do a survey with banks, with the institutions, to see really how many accounts are signed that way, because otherwise, if you insist on this, it means we cannot open the account. Simple. Because some people insist, I'm just saying, repeat, because it has been audited, it has been reviewed, and we didn't want, for risk reasons, I agree with you, for risk reason, we wanted to send the account. They refused completely. So, the question is what we do.
Just one thing on this point in particular. Under Swiss regulations...
Please, let's use the microphone, yes.
Under Swiss regulations, it's allowed that you hold mail, provided that either you have online access to the account, and they can monitor if you are accessing it at least once a year, or you collect yourself the mail within a 12-month period. If this is not the case, they send automatically to the default address. So this could be a solution to this particular problem.
The language implies, I don't think we're disputing here the right of the client to receive the statement. The language implies as if the client cannot waive this right voluntarily. That's my question.
Okay, then, do you have a question? Please, yes. Go ahead. And we have to wrap up in a couple of minutes. That will be the last question we're going to take, yes.
Bassam Frame from BSEC. I have two questions, both related to the custodian. First, we saw yesterday that there's a license for the activity of a custodian, and now we see that Mintclear is the only custodian. So,
it's out, yeah.
Excuse me. Just to be very clear, I just got a message. I just want to be very clear on it. Mintclear is automatically licensed, while the others need approval from CMA to perform a custody, right? So we're not suggesting or disputing that there is a monopoly here, right? So this is an issue that we can certainly take under consideration, and we will give it the proper attention.
Okay, the second question, it's related to our part, securitization law. A custodian is required by law. However, the custodian needs to have custody of the assets held by the fund, which are usually different than what we have, the notes themselves. And the law states that there's a liberty to choosing an independent custodian. Is it necessary that Mintclear be the custodian for such funds?
The regulations regarding funds and all forms of collective schemes will be in the collective investment schemes regulation, which is currently in draft internally at the CMA. So, as regards custodians for funds, there will be specific rules in that regulation.
But this have been requested and imposed to have the Mintclear as custodian before having these...
Okay, allow me to jump in. The requirement wasn't to have Mintclear per se. The objective was, if you recall, when you submitted your applications for the securitization, the law states or the circular states that the custodianship should be done by an arm's length entity or institution that doesn't belong to the institution that is issuing the product. And failing from being able, and this was a challenge as to how can we help you, if you recall, finding that kind of custodian while keeping in mind there is the confidentiality that you guys are quite concerned about in having or disclosing the client's names to other institutions if they jump in and stand up to say, we want to be another custodians besides Mintclear. So that's why we literally had to seek the help, if you recall, of Mintclear to jump in and take custodianship or supervision of another entity to make this particular role. So the rule of thumb, I mean, I know it seems there's a lot of concern on the monopoly issue. This is something we're going to take back and look at it.
So this is the exception for now. In general, there's a liberty to choose for this particular case a custodian.
I would like to say yes, but again, we're going to reflect on this and get back to you.
Thank you. We'll have a break now for around 20 minutes and then get back into session. Thank you.